That is all, eh?
No, my Lord, just on the issue of judicial notice, Learned Counsel for the respondent hinted about it, that the answers should be judicially noticed, but no prayer was made. I'm praying that they be judicially noticed under Section 56 of the Evidence Act.
Is it the question of counsel asking us to judicially notice, or the law sets out what must be judicially taken notice of?
My Lord, it is the position of the law.
It's like the Gazette, the House of Parliament, the Gazette, the official publication.
There's a provision in the Evidence Act, but I forgot which section.
My Lord, it is Section 56.
56.
Of the Evidence Act.
At least what are judicially taken notice of.
Yes, my
Lord. So once you know it is provided for there, we don't have to say what.
Much obliged, my
Lord. We will state so in our judgment if we agree that it falls under that.
My Lord, let me dive right into my submissions regarding the proceedings, in addition to the submissions of counsel.
How much time do you need?
My Lord, about 20 minutes. This was given to the rest of my colleagues.
Proceed, you have your 20 minutes.
Much obliged, my Lord. My Lord, I would like to start with the record of Parliament for the 27th day of September 2017.
You are dealing with the issues 1 to 4?
1 to 4, my Lord. I'm just adding facts. My Lord, in this record, I would like to highlight, number one, that this is the day that the bill, the Honorable Magezi laid the bill. My Lord, at page 4741 of the answer of 27 September 2017, my Lord, in the first column of that page, the printed page.
Your record is not numbered.
My Lord, I humbly pray that we refer to the printed page of the answer.
Then guide us so that we are all on that page.
Much obliged, my Lord. My Lord,
I am there, but I found that.
My Lord, it is printed page 4741.
And the record is not highlighted. It helps your case and shortens the time.
Much obliged, my Lord. We pray for your indulgence. I'll try to refer to them in terms of paragraph and page. My Lord, the motion seeking leave in Parliament 4741.
Yes.
My Lord, on the 27th day of September 2017 is when the motion seeking leave of Parliament to introduce a private member's bill entitled the Constitutional Amendment Bill of 2017. That's the day when Honorable Raphael Magezi sought leave to introduce this private member's bill. My Lord, I would also like to highlight the closing remarks of the Honorable Speaker of Parliament, that is at page 4746.
So,
4746, printed page. My Lord, the second paragraph of the second column on that page. The Honorable Speaker of Parliament stated as follows, and I'll quote her verbatim. Honorable members, as you proceed with the processing of that bill, I would like to remind you about 4746. Printed page, my Lord. Up there. My Lord, she said that she would like to remind the honorable members about a few things. The sovereignty of the people under Article 1 of the Constitution of the Republic of Uganda. She restated the provision verbatim. She went ahead, that is the part that is in italics, my lords. She also stated that the question on who shall govern them was settled in February 2016. Now what you have to seek is how. Therefore, the people are central to this issue. It is not an issue that we can decide exclusively without the population. My Lord, these are words of the Honorable Speaker of Parliament. She highlighted the fact that there was need to involve the population. And my Lord, this goes back to the issue of social contract, which Learned Counsel Mbale talked about, and this fact speaks clearly about it. My Lord,
at this stage was the matters now being challenged in issues 1, 2, 3, 4. Was it already before Parliament, or was it before that?
My Lord, what was in the bill was mostly about the age limit, and that was covered by Council. I do not want to repeat it, but what the contents of the bill are Annexure A to the petition. And for purposes of brevity, I didn't want to go back into that. But the Honorable Speaker kept reminding the Parliament, and I'm going to highlight the other areas, even when these issues were introduced, where she queried their introduction into the bill without consultation of the public. My Lord, the timeline goes that on 28th, if you look at the bills that are attached to the various petitions, on 28th September 2017, the bill was gazetted. It is Annexure B to the petition. My Lord, if you look at that bill, it did not include the provisions that are being challenged. I just wanted to marry the earlier submissions with the facts that are presented in the petitions. My Lord, I would like to move on to the Hansard of the 3rd October 2017. My Lord, at 3:33 of that day, that's when we had the first reading of the bill. The first reading of the bill, Honorable Raphael Madezi begged to move that the bill entitled the Constitution Amendment Number 2 Bill 2017 be read for the first time. Beg to lay it on the table with a certificate of financial implication under Section 76 of the Public Finance Management Act of 2015 and Rules of Procedure, Rule 107. My Lord, the issue of the certificate, I think, will be covered by Mr. Mbale, as he was given the document out of discovery, and he'll address it. My Lords, I'll move on to the second reading. The facts speaking about the second reading of this bill are in the answer of Tuesday 19, December 2017. That is page 5137 of the answer. My Lord, again, I will quote verbatim what the Honorable Speaker said at this level of the life cycle of the bill.
What is the page, Council?
5137 of the answer of Tuesday, 19th December 2017. It's annexure F3 to the petition, and it is the second page of annexure F3. My Lord, at this point, the learned Speaker, the Honorable Speaker, there were new matters that had been introduced in the bill, and she's had this to say. In the chairperson's paragraph. My Lord, the last paragraph on the first column, moving on to the second column. That paragraph beginning, in the chairman's report, there are two matters that were not originally part of the bill. One is the issue of term limits. We would like to know under whose instructions that part was addressed. There was also the issue of adjusting the tenure of the President. We would like to know how it was canvassed. Then, crucially for issues 1 to 4, she also said there was also the issue of adjusting the term of Parliament. Honorable members, when we give responsibility to a committee like this with a bill, we expect them to address the bill and not go into extraneous matters. Therefore, I would like to know from the chairperson to whom the recommendations you made were addressed to, and how did they come to be part of your report? My Lord, once again, this is the Honorable Speaker querying, just like we are querying, these additions and putting the chairperson to task. How did these things come? They were not part of the bill. Now, my Lords, in response, the chairperson of the committee, that is the chairperson, Committee on Legal and Parliamentary Affairs, Honorable Jacob Mbale, I will quote at page 5138 in the second column, the second paragraph, beginning with the parliamentary tenure is not captured in our report. My Lord, this is direct from the chairperson. He's saying that this particular issue of the term or the tenure of Parliament was not part of the report. And there was laughter. And he went on to say, now, for those who are laughing, we all know that the presidential term we had proposed here was also not in the bill. Madam Speaker, we tried to scrutinize the bill. We did not agree with the bill entirely as a committee, and I had no problem introducing my friend until a few minutes ago, who headed the subcommittee scrutinizing something that is not in the terms of reference, but a method of work that was adopted as a chairperson. My Lords, I would like to highlight the fact that he admits that the issue of the parliamentary term was not part of the report of the committee, and that it was not even part of their terms of reference. My Lord, on the same page, the Honourable Speaker, in her wisdom, further guided at the last paragraph of that column. The Honourable Speaker stated, Honourable Chairperson, I'm not saying it is not the truth. What I am asking is, what do you expect this House to do? Don't you think that those would be a subject of separate bills on their own right in the House? My Lord, this is still wisdom. The Speaker is still trying to guide honourable members of Parliament about how they should handle this bill properly. And my Lord, this is clear. It is clear that to her, even to her, these things were smuggled into the bill. Now, my Lord, I also wish to quote some excerpts from people that were members of the honourable members that were part of the committee and what they stated. My Lords, at page 5142, that is the last paragraph of the second column, Honourable Medad Segona stated this. He said, it is not true, to the best of my recollection, that we had any memorandum submitted in relation to the 7-year term, whether of Parliament or of the President. My Lord, again, this is another member of the committee confirming that these things were not even part of the memorandum that they received as a committee. My Lord, Honourable Mohamed Sinsereko at page 5141 also stated this. I would like to put you on notice that during our sittings in the committee, at no single moment did anyone appear before us and state clearly that they want a 7-year term extension for Parliament. My Lord, all this goes to show that even at committee level, they did not receive these things. My Lord, again, Honourable Amoding at page 5143 also stated as follows. That is the second column. That would be fourth paragraph. She stated that, Madam Speaker, I am a member of that committee and I sat in almost all the hearings that we had as a committee. There was not a day that we received a proposal that as Parliament we extend our tenure for 7 years when we went for the retreat. My Lords, once again, this is confirmation that even at committee stage, these people, the honourable members of Parliament who sit on that committee never received that proposal.
How much more time do you need?
I'm just...
You have used to solve your time. How much more time?
My Lords, if I could be given 10 more minutes, just I'll skim through quickly.
You have 5 more.
Much obliged, my Lord. My Lord, I'd also like to draw your attention to page 5149, where now we have at the second reading of the bill, 5149, Honorable Minister of Defense and Veteran Affairs, Mr. Adolf Mwesige, states something that Senior Counsel Gallo hinted about, the justification. 5149. My Lord, he starts at 5148.
Yes. Then say he starts at 5148 so that he follow.
Much obliged, my Lord. He starts at 5148. I'm specifically quoting from page 5149, the second paragraph beginning with, I would like to agree with the recommendation of the committee that indeed the 5-year term given to President and even Parliament is not sufficient going by our experience. It is not sufficient for the President, members of Parliament and local governments to execute their duties effectively and have the impact that Ugandans would desire. My Lord, Honorable Gallo, Senior Counsel Ogallo pointed out that they said, if a member of Parliament is new, you use the first 2 years. My Lord, this is where that is captured. We all know that if somebody is a new member of Parliament, the first and even second year is spent learning procedure of Parliament. The third year is spent serving our people. The fourth year, one is going for primaries. And the fifth year, one goes for election. Clearly, the time left for a member of Parliament to make an impact for his or her constituency is simply 2 years. My Lord, this is where that bit is captured, and I wanted to highlight that for purposes of the submissions regarding the legal implications of such a suggestion.
This was a presentation by Mr. Mwesige?
Adolf Mwesige, yes.
He seems to have been speaking on behalf of government, not on behalf of the constituency in Kabarole.
My Lord, once again, since the answer to the judicial notice of what happened in Parliament, we don't need to read into what their intention was when they brought this amendment.
No, here it is indicated. The Minister of Defense and Veteran Affairs is the one speaking. If he represents a constituency, I don't know why it's not indicated here. I'm just wondering. Then I would know he's beholden to some constituency, either urban or rural.
My Lord, from the record, it is reflected that he was speaking as the minister, not as the MD.
Okay, continue.
For Bunyangao. My Lord, I'd like to quote again from the answer of 19th December 2017 at page 5151. The remarks of Honorable Mary Kabana. She thanks the Speaker, that is in the second column, second paragraph there. Thank you, Madam Speaker. I would like to oppose the motion and also the report and the bill because Article 1 of the Constitution gives power to the people. We were given money to go to our constituencies and districts to bring views. Unfortunately, in the report that was presented by the committee, those views are nowhere to be seen. Therefore, I think the report is incomplete. My Lord, again, to marry with the fact that there was an issue of social contract. They had the obligation to go back to the electorate and even were given money. Now, if those views, according to the Honorable Member of Parliament, were not even in the report, I know that shows you the flaws and how Article 1 of the Constitution was violated, the extent to which it was violated.
Some of these are you submit. Sorry, okay. Very well.
This our ministry will have his time, it's okay. My lords,
No, he was giving you a standing ovation.
much obliged, my lords. I'm thankful for his magnanimity. My lords, from the Hansards, the debate, further debates also went on 20th December 2017. For brevity, I will not highlight some of the proposals that were discussed. My lords, I also want to highlight the proceedings of 20th December 2017 at pages 5248 up to 5249, when Honorable Tusime now gives details of some of the provisions that are being challenged. And this is for purposes of confirming to court at what stage these these amendments were introduced in when they were discussing the bill and the act eventually. My lord, this is the stage when now we get a detailed breakdown of the provisions that were proposed. All along they had just been hinting about them. If you look at the committee report, they are not there. But now, in the answers, on 20th December 2017, you see Mr. Honorable Tusime reading them out. And I believe this was at the time they were debating. Okay. That is at page 5248 to page 5249 of the Hansard of 20th December 2017.
Right.
5248, my lord, to 5249. The answer, my lord, it begins from amendment number 2 at 5248. They talk about Article 77 of the Constitution to be amended in clause 2 by substituting the word 5 appearing immediately before the word years with 7 years. Now this is when you get the full breakdown of the amendments that are the subject of the petition is before you, my lord. My lords, I would also like to highlight the submissions of Honorable Amongi at page 5252. That's the second column, where she even highlights some of the provisions that we as petitioners have talked about as having been contravened. One of them is Article 77(4). Clause 4 of the Constitution, Article 79, I think, which was talked about as well, My Lord, she highlighted these facts, and I will not read, it's a bit extensive for purposes of brevity. But all these issues were raised, and they were comfortably ignored by the, like you said, because of the dictatorship of the majority. My Lords, these were ignored. But, my Lords, we are before you to examine whether what they did is constitutional. And, my Lords, these areas that I'm highlighting are instructive on the facts that of what transpired in Parliament. My Lords, I would also like to highlight, now going to the report of the Central Committee.
Council, you've submitted for 35 minutes.
My Lord,
15 minutes.
Much obliged, my Lord.
Outside your time.
I'm not full of it.
You pointed us to us where we can find when certain things happen. That's okay. We have understood.
What
My
is
Lord,
the point?
my Lords,
What point are you trying to make?
my Lords, like we agreed that I will not repeat what was stated by my colleagues.
Yeah.
Now,
We applaud you for that.
what has been submitted before excluded facts. There's need for us to submit evidence.
So you're ground 6.
No, my Lord. Some of them speak about ground 6, and we'll also highlight that. But for purposes of the issues of law, like for example, if we are saying that the amendments contravene article.
No, the only thing I wanted maybe to understand, let me put it like this so that you may correct me if I'm wrong. That the bill that eventually became the Act of Parliament, its enactment did not follow the procedure, the required legal procedure, and was incurably defective from beginning to end, that it could not have ended up into a legal enactment. And this is how it was. On this day, this was not done. Consultation, not there. What is not there? Page 3, highlighted. Page 5, but you are telling us that so that we do what?
My Lord,
we want to know, okay, and then the speaker said, and then speaker simply said, what do you mean?
much obliged, my Lord, and I believe that was the conclusion that I was going to draw after highlighting
No,
all those
not
provisions.
just draw the conclusion. You tell us the road. Here I'm going to, from Mbale, I am going to Soroti, and this is what happened on the way. Road block, bridge, rain, heat. So we know what you have done. But if you just tell us, you got the road block, then you got one.
My Lord, much obliged, having highlighted all the roadblocks, my Lord, to borrow your words, that this bill suffered on its way to becoming an act. It is my humble submission that it was a nullity from the word go and unconstitutional for them.
I thought you were saying they dismantled the legal roadblocks on the way. Isn't that what you're saying?
No, my Lord, I'm saying that the roadblocks that were placed before the voices that tried to take them in the right direction, for them to arrive at the right.
If I understood you, not at council, you cited evidence, the activities in Parliament, where when this matter came, the Speaker, before that, the Speaker even wanted caution. And then when they introduced again, the Speaker said, don't do this. If we do, we should take care of this. We should be mindful of this, paraphrasing. And then, so these safeguards, we could make for a properly enacted law were all dismantled, in the passage of that making that law.
How did the Speaker end up passing a law that, for herself, right from the beginning, considered so perceived that the whole procedure was irregular?
I know that I would not.
No, I'm just answering.
Go so fast to speculate how she
it's
did
not about
it.
speculation. It is the direction you see.
My Lord, I believe that
the procedure was so flawed that even it was so apparent to the speaker, all members, right from the beginning.
Yes, my Lord, much
Did she overrule the chair of the committee of the parliamentary legal assembly when was being said, no, I overrule your attempt to bring the issue of extension to life of parliament because of my other question, earlier question.
My Lord, I will borrow the words you used earlier when Council was submitting. It was tyranny of numbers.
No, the evidence. No. Not in council.
Yes.
That the issue of which I said I understood them to be referring to tyranny of the numbers. That's my understanding. But this one, regarding the speaker rules, and want to know that when there was that attempt to bring the speaker, say, I'm not allowing that. I should like to think the speaker's got powers to do that. Where because you're dealing with evidence. Where is the evidence? Then we answer my Lord's question. That the speaker, when this matter was brought, said, you people, you don't listen, I have questioned you 1, 2, 3 times, you're going ahead with impunity, I'm not going to allow this type of impunity, I'm not allowing it. And then you say, the majority now, using their tyrannical nature, overrode the speaker. I would love to see.
My Lord, from my peruse of the answers, there was nothing like a ruling on that.
That's what my Lord is asking you.
However, my Lord,
so in brief, if I understand my Lord, he said, speak for himself. Despite all these questions, why did the speaker allow? The power is there with her as Speaker of the House to say, no, I'm not allowing this. I don't know. Maybe I don't understand.
My Lord,
maybe the rules say the Speaker cannot.
My Lord, I believe that
does the Speaker have power to permit illegality, procedural illegality, which she herself has perceived and is on record? Pointing to us the irregularity is one thing, but you have to go further and convince us or tell us about the import of that in the matter before us.
My Lord, much obliged.
Just to bring the point home, you're now submitting on this. If you were to begin here submitting what is happening in the second market today, I would overrule you and ask you to sit down because it's not material to this, it's not part of these proceedings. You're trying to sneak in. Even if the other member of parliament who introduced the bill was beating up people in the second market today, I would say, what has it got to do with the petition? I would stop you from that. So the question is, did the speaker exercise that power vested in her by law? Say, no, I'm not allowing this. Because it's smuggled in. I think either Mr. Dokwango, one of the people who said, I think Mr. Mbale said, it was smuggled in.
It is akin to proceedings in court where the presiding judge points out that counsel, but the evidence you are talking about, this issue was not pleaded. You didn't call a witness to adduce it or something. And then in the judgment, he bases that his decision on the evidence that was neither pleaded nor adduced, forms the basis for his judgment.
Anyway, conclude.
Much obliged, my Lord. In response to your guidance, my Lords, I believe that's why the petitioners are before you. Because in the case of the example given by His Lordship Justice Kapuru, you go for an appeal, you don't go back to the same judge. This functus official, if he doesn't, you can't go back to the Speaker. She has already made the decision and allowed the bill to go through to become an act. That's why honorable members of parliament, members of public, an advocate who is my client.
No, you're not getting the point. Learned Counsel, you're not getting the point. What my Lord and I are saying, yes, at the beginning she said, don't bring experience matter, against repeated, maybe 3 times, I don't recall. After doing all that, she then allows the process to go on and explain. You get what I'm saying? So to what they was I saying, don't do this, and then at the critical moment, at the time when she should have stood up to be counted, she did not.
My lords, like I said,
tie that to your conclusion and this.
Yes, much obliged, my lord. My lord,
guide us knowing that the speaker is not coming here. We are very, very
I believe that's why one of the petitioners wanted her here for cross-examination. But my lords, in conclusion, throughout the areas are pointed out, and many more, because there are other honorable members of parliament who even told the House that this is illegal and we are going to go to court and it will be thrown out. Just because we don't have enough time, I will not highlight, but there are records.
But
parliament
even if you are not saying it,
yes,
would you bring in a petition?
My lords, in conclusion, I would like to associate myself with the submissions of earlier council regarding the unconstitutionality of the provisions that are highlighted in issues number 1 to 4, and I humbly pray that on those issues, court finds in favor of the petitioners, because the evidence, as I've highlighted, clearly shows that the procedure was flawed.
Thank you. Mr. Mbale, do we have another person on the legal side? Just a moment. We don't have 2 people standing. Mr. Mabirizi, good things are normally for those who wait, those who are patient.
No, my lord.
On the land,
on the side of my land,
very well. Yes, Mr. Mabirizi.
Thank you, my lord, for the record. My name is Mbale, Mabirizi Shwanuka. My petition is number 49 of 2017. My lord, I stood up the other time because of the facilities here. But I can't check my documents when I'm seated.
Can't check?
I can't be able to check my documents when I'm seated. So that's why
okay.
Sometimes you may see me standing up.
Please, you can stand.
So
you
my
can
lord,
even stand for other reasons than checking the references.
my lord, on the record of my petition.
No, maybe. What are you tackling? How do you intend to tackle it? What period of time do you require us to grant you?
I first wanted to highlight what, because I have indexes on my record.
No, that one comes later.
My lord, there are some things I don't agree with from Land Council. There are some points where I want to associate myself with.
On issues 1, 2, 3, 4.
Yes. Mm-hmm. But again, my style of arguing issues 1, 2, 3, and 4 will be that I'm going to argue for those issues together with some few issues which are interconnected. I want to argue them.
Which 2 issues?
I want to argue them together with issue 7B4, 7B Roman 4, then together with issue number 8, and issue number 10. Yes, my lord, because all of them rotate around the method used and the process, the constitutional processes which were not complied with. That's how I'm going to argue them. But my lord, before that, I will also I wish to address you on your duty as this court, briefly. I wish to address you on the burden of proof. And I wish also to add something little on the principles of constitutional interpretation, and then something little on constitutional history. That will be the introductory part.
What do you mean constitutional history?
As an integral part of the principles of constitutional interpretation. In this case, I will bring out...
So what I'm saying is, it's in Uganda or the whole world?
I bring out in Uganda the decisions where constitutional history...
constitutional history. Of where? Of the world? Of Uganda?
Of Uganda, and some few countries...
East Africa or...
And some few countries which have had a similar history of ours, to show that it is so pertinent in aiding court to interpret...
What period of time would you need to...
My lord, on these preliminaries, duty, burden, history, and then pointing out what I don't disagree.
Duty, burden...
Duty, burden...
How long do you think it will take on duty of this court and the burden?
About 15 minutes.
Really? To tell us who carries the burden of proof?
No, but you have also put on the duty.
I'm asking. And then you tell us the duty with the proof. We are happy to know. Probably to be reminded to the of this court. 15 minutes?
The duty of this court, I may need about 10. At the burden, I need 5 minutes.
On the burden? On who the burden lies? I hope we are talking about the same thing.
It's vice versa. To whom the burden lies, 5 minutes.
On whom, yes. Right?
On the duty of this court, 10 minutes.
So on all those things now, how much time do you...
On?
Yeah, everything up to...
On the preliminaries, because I don't want to mix the two. Because I have to tell you what I don't agree with, then I go to duty, the burden, principles, and constitutional history.
Why don't you put your brother, Mr. Makilis?
Yes, my lord.
Why don't you arrange to present your case within 20 minutes?
My lord,
we see.
I pray that you allow me 20 minutes to go into these preliminaries which I'm telling you. Because
no, for me, I want to know the period of time I should give you. What time? Because
my lord,
what time do you need?
Since I've already know this issue, give me 2 hours. Because I don't want to be playing for...
You will not get 2 hours.
My lord, it's my prayer. And you promise not to stampede us, to let us...
No, it's not about stampeding.
Because, my lord, I want to be honest to you.
You know, let me tell you, you set the parameters. Your pleadings, issues have been framed out of those pleadings. We know what time you would need to inform us, and we retire to write the judgments. It's not a lecture room. You're not presenting a paper in somebody's memorial. You're addressing us on things you're very familiar with. So just point out, say, look, on the burden of proof, the law is well settled. The constitutional petition like this, it lies with the Attorney General, if that's what you believe. Then say, look at this authority. 2 minutes, you are done.
Yes, my lord.
I think you are very well prepared, and probably more prepared than some of the lawyers who have come, because you have submitted your comprehensive notes and your skeleton arguments in a document that is 106 pages. The document is here, well written, on record, everything, petition, compliance, you have quoted. Why don't you begin by asking us to adopt this as skeleton arguments, and then you proceed? Because what is the point of you orally repeating what we already have in writing? 107 pages, which we have read already, so that we don't see.
Most obliged, my lord. Actually, I'm not going to be repeating. But I'm going to make two applications. One is for...
Do you agree with that? Because of this, you don't need 2 hours. But we already have 100.
But again, not 20 minutes, my lord.
We have given you 20 minutes. Can you begin now?
So, my lord, I begin by adopting my conferencing notes. Secondly, by requesting court to adopt the discovered documents. The documents were discovered by the respondent. And thirdly, my lord, I should point out where I don't associate myself with the first petitioners. One, I don't agree with Honorable Mbale Ogalo that Articles 1 and 2 of the Constitution were merely infringed. Actually, my submission is that Articles 1 and 2 were actually amended by implication and through calendar legislation without following the right procedure provided for by the Constitution, which is one, separating the second and third readings with 14 sitting days of Parliament, and two, referring the matter to referendum by the people before it was assented to. Secondly, I don't agree with Mr. Byamukama when he submitted that.
Just proceed. For us, we shall look at your submissions and look at them and decide whether you agree or you don't agree.
Most obliged.
So my lord, leave that to us.
Because you should not appear as if you are attacking them.
Yeah,
you should be attacking the respondent, not.
Just proceed on your own road.
Okay, my lord, I have
your own lane. So
I have 3 documents on record, which I call Index 1, Volume 2, and Volume 3. The first one is blue, another one is white, the third one is not bound. So I summarize my authority there. So when I say index this, just to ease so that I don't speak so many words and where it is found. My lord, I also have a Hansard index. Where I'm going to provide with the Hansard, I summarized that. So that again, you don't spend so much time. I also have a skeleton of my arguments. It has Mbale's skeleton. Yes, my lord. So, my lord, on the duty of this court, the duty of this court, my lord, has been stated in the decision of Semogere versus Attorney General by the Supreme Court. And I'm now referring to my Index 7 of my authorities. And I'm going to quote Justice Kanyahamba. He said that in Uganda, courts, and especially the Constitutional Court, my emphasis there, and were established as the bastion in the defense of the rights and freedoms of the individual and against oppressive and unjust laws and acts. Courts must remain constantly vigilant in upholding the provisions of this Constitution. So, my lord, that is your duty as specified in that decision. My lord, in America, when we go to my index 223,
which index 1?
I think it is in volume 2, 223. It's in volume 2 at page 85. The case is Citizens United versus the Federal Elections Commission.
Volume 2, the one I have, stops at page 54, the white one.
Yes, but page 13. Page 13, there is number 223.
Okay.
Those are the words of Chief Justice of USA. He said, judging the constitutionality of an act of Parliament, Congress, is the bravest and most delicate duty that this court is called upon to perform, because the stakes are so high. So, my lord, in this case, the stakes are so high, and your duty is so brave. My lord, you should indeed stand out, just like the Chief Justice of the USA says that the duty is delicate, but at the end of the day, you are called upon to do so.
I thought you'd add that, fortunately, you know we are equal to the task. I was waiting for you to say that.
That is the better word, my lord. That you are equal to the task.
You know we are equal to the task.
I have no doubt.
Otherwise, you would not have come before us.
My lord, I go to burden of proof. My lord, the burden of proof has been defined under my index 268 in the case of Mbale versus Museveni. In that case, it is my index 268 in volume 2. The court said the burden of proof is the imperative or duty on a party to produce or place evidence before court. Evidence that will shift the conclusion away from a default position to one's position. It is the necessity of affirmatively proving a fact in dispute on an issue raised between parties in a cause. And then, my lord, the land justices who were 9 then, at my index 402. 402 is in this unbounded. They said, the legal burden rests on the petitioner to place credible evidence before court, which will satisfy the court that the allegations made by the petitioner are true. If credible evidence is brought before the court, the burden shifts to the respondent, and it becomes the respondent's responsibility to show that there was no failure to comply with the law. That's in my index 402, my lord. And my last authority on this is the Kenyan decision of Raila Odinga versus Uhuru Kenyatta. At my index 282, the justices say, through the legal burden and evidential burden of establishing the facts and contentions which will support a party's case is static, remains constant through a trial with the plaintiff, remains constant through the trial with the plaintiff. However, depending on the effectiveness with which he or she discharges this, the evidential burden keeps on shifting, and its position at any time is determined by answering the question as to who would lose if no further evidence were introduced. My lord, I conclude with section 6.
What is the threshold when does court say the petitioners given sufficient material that shifts the evidential burden to the respondent?
My lord, the Kenyan case.
What is the measure?
The Kenyan case says.
Is it a thermometer? I mean, how do you get it?
It depends on the effectiveness with which court can normally determine that now it is effective. It can't be answered.
So it is left to court.
Yes, my lord.
If the court thinks it is not, even if you believe it is left to court. It is court's discretion.
But my lord, section 106 guides you. It limits your discretion.
What does it say?
When it says, at your mind is 120, that in civil proceedings like this, when any fact is specially within the knowledge of any person, the burden of proving that fact is upon that person. So 106 somehow negatives the general rule on the burden. That in situations where we may find that the Attorney General has to prove some things which are mostly in his possession, then the burden shifts, my lord.
It would. I can help you on that matter. This is that provision in the Evidence Act supports the issue of discovery.
Yes, my lord.
The proceedings of Parliament are with the Attorney General and the respondent. If you wanted it and they cannot give, you would submit and say, not the evidence is with the respondent will be ordered to prove that what I'm saying is false.
Yes, my lord.
Then that evidence of that shifts.
And when I come, the certificate shall also rise. My lord, I now move on to the general principles of constitutional interpretation. I will add on that, my lord, Parliament was actually put on alert that it had to do whatever it was doing while following the principles of constitutional interpretation. My lord, in my index, my Hansard index, paragraph 3 is a statement, actually 3 and 4, by Lieutenant General Henry Tumukunde on the floor of Parliament. General Tumukunde said, let me be on record, especially on matters why we must amend the Constitution and the effect of amending it. In the case of Semogere versus Attorney General, I shall rely on it extensively. The precedent of the Queen versus Bill, the grand constitutional case was determined. I would like to read to you this quotation. Then he read the decision of the Supreme Court in Semogere versus Attorney General. He was warning Parliament that what you are doing, you must be careful. That when you try to tamper with one article, you may end up amending articles to which you have no authority to do. So again, my Lord, I will go on to refer to another case. Again on the principles. That is the case of, it's a Kenyan case. It's at my index 232. It is Center for Rights and Education Awareness versus the Speaker of the National Assembly of Kenya. The court said, it means that the power of the people is superior to both, and that where the will of the legislature stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by fundamental laws rather than by those which are not fundamental. So, in this situation, we have the will of the people in the Constitution, and then we have the will of the Parliament. This decision says, interpreting the Constitution, my Lord, you follow the will of the people. Don't follow the will of the 317 members, my Lord. My Lord, in that same decision at my index, 235, court says,
my problem, I have a problem.
Yes, my Lord.
In determining the will of the people, which is in the Constitution.
Yes.
The Constitution would have been debated, promulgated by people elected, by representatives of the people elected in the same way members of Parliament have been elected. In other words, you don't gather all the people of Uganda at one place here.
My Lord, they are not elected in the same way.
Listen. You don't gather all the people here to make a constitution. And then, after that, they elect representatives to go to Parliament. Then it will be easier for me to say that, no, that one, all the people gathered, I don't know which place in Uganda will collect every Uganda. But this one here, it was received through members of Parliament, and it's not equal to the people of Uganda because it's similar.
My Lord, as I go on, I will address you on two principles. Color-level legislation and the doctrine of constitutional replacement. This Parliament we have has no constituent authority. A constituent authority is obtained when people agree that let's vote people to go and make a constitution. That's what they say.
Mr. Mbale, what does the Constitution say about amending itself?
The Constitution says...
Listen first. Does it say you must always go back to a constituent assembly? Or does it permit Parliament, as Parliament, to amend?
The Constitution says Parliament can amend subject to the provisions of the Constitution. In this case, Parliament purported to amend without complying with the Constitution. Specifically, Chapter 18. They amended Article 1, they amended Article 2, they amended Article 160 of the Constitution without separating the two sittings with 14 sitting days of Parliament and without referring about the referendum.
So amending by implication.
Yes, we call it color-level legislation. That's the words of order, just from Supreme Court. Just internal peace.
Order, not order.
Order.
Yes, you just read it the way you read Latin. O-D-E-R, order.
Thank you, my Lord. So, my Lord, I was at my index 235 as I conclude on principles. It is said that court decisions cannot be ad hoc. They must be justified and perceived as justifiable on marginal grounds reflected in the previous case law and other authorities that apply to the case at hand. My Lords, your decision will not be ad hoc. It is a decision to bind us. So interpreting the Constitution, that's also another aspect that you are going to decide for our generation that are going to come in the future. And my Lord, at my index 313, there's another decision of Kenya.
You know, there's a saying, there is an African saying, I wish I knew which community, I always keep on reminding. And when we make a constitution, when we write a judgment, it's not for the people of yesterday. It's for the people, and I think my Lord said it yesterday, for us who are present today and for future generation, posterity. The African saying is that the land which we occupy, the one which we till, is not what we inherited from our ancestors.
Yes, my Lord.
Contrary to what is always believed. It is actually what we have borrowed from future generations. So we must use it and give it back to the owners. In other words, the more important people than the future generations.
My Lord, I'm obliged. Because that's your principle. My Lord, my last aspect on principles of interpretation, if I go to history, the decision at my index 313, it is a Kenyan decision. It is Katiba Institute and another versus Attorney General. At my 313, it is in the white one, volume 2.
You just got the page, you are on page down, not
It is at, yes, but it starts from page 11. But it says, the Constitution, actually says, the general provisions governing the Constitutional interpretation are that, in interpreting the Constitution, the court would be guided by the general principle that the Constitution was a living instrument with a soul and consciousness of its own, as reflected in the preamble and fundamental objectives and directive principles of state policy. Courts must therefore endeavor to avoid crippling it by construing it technically or in a narrow spirit. After someone, they said, a timorous and unimaginative exercise of judicial power of constitutional interpretation leaves the Constitution a stale and sterilized document. So, my Lord, this is a very big principle. That you look at the Constitution as a body, that when you touch my hand, the heart feels. When you touch my toes, the head feels. So, you interpret it as a whole, not just speaking one thing, that Parliament has powers, and then leaving out the procedure it has to follow. So, my Lord, that was what I wanted to add on the general principles of interpretation. My Lord, on constitutional history, as a pertinent component in interpreting the Constitution, I rely on 3 authorities of this country. The first authority is at my index 65. Sorry, my Lord, before I go there, I need to state that at my index 65 of the Hansard, my Hansard index, Parliament was warned that it had to treat carefully with amending the Constitution because of the constitutional history of this country. Honorable Kyagulanyi was clear. He said, today we have the opportunity to determine the future of Uganda. We have the opportunity to break or make the future. Honorable members, I would like to remind you that in 1966, an abomination happened right here in this Parliament when the Independence Constitution was murdered in cold blood. And by the leaders of that time. The outcome of their actions sentenced Uganda to a long period of political instability. When President Idi Amin came to power and suspended this Parliament, no single Ugandan rose to defend this Parliament. Why? It is because it had become irrelevant to seek their personal interest. And members gave him an applause. So this Parliament was warned. Now, my first authority on this issue of constitutional history is Sechikubu and others, Pastor Attorney General. It's at my index 26. That is Supreme Court Constitutional Bill number 1 of 2015. My Lord, in that authority, the Supreme Court was called upon to determine whether, if a party suspends its member, it is to be an MP. And the Constitutional Court looked at the history of how we came to have that clause in the Constitution. And it found that members, people in the Republic wanted accountability, and found that actually the interpretation given by this court was not correct. My second authority is Karuhanga versus Nigeria.
Now, I just wanted to tell you, you've consumed your 20 minutes. I'm giving you 10 minutes, and I will not extend it anymore. We didn't wish to finish everything that you have to submit. So choose how you do it.
I do what?
Choose how you do it. You're just dwelling on these authorities instead telling me there is this authority, it deals with this, go to the next authority. You're assuming we don't read. We read. It's 10 minutes. If you dwell on other things which you think are important,
my Lord, my prayer is this.
I'll call the Attorney General to respond.
My Lord, my prayer is this. Allow me to address you on carriable legislation.
I've not stopped you. I've given you 10 minutes.
No, I'll make that advance prayer.
It is all here. Very well good. I like your documents. You've given us. Everything is here. If you had highlighted this, it would even have been even better, because we have just got the highlighted points. These notes are here, your authorities are here, they all have.
Thank you, my Lord. My Lord, Kasula had something.
Just proceed with your.
That's obliged. My Lord, substantively, my Lord, I'm going to address you on carriable legislation. It's my submission that Parliament, without the authority of the Constitution, amended Articles 1, 2, and 260 of the Constitution. My Lord, when you look at the bill, the Act now, as a whole, maybe I need to first define carriable legislation. It's at my index 100.
You define or you tell us how to define it?
How it was defined by the Supreme Court in Semogere versus Nigeria. It was said that a carriable legislation occurs where a legislature lacking legislative power or subject to a constitutional prohibition may frame its legislation so as to make it appear to be within the legislative power.
Is this in volume?
It is in 100, I think, is in volume 1. Volume 1, the blue.
The red one?
The blue one.
Okay, this one.
Yes.
Page.
It's at page 24.
Page?
24.
Yes.
So his leadership was saying that a carriable legislation occurs where a legislature lacking legislative power or subject to a constitutional prohibition may frame its legislation so as to make it appear to be within the legislative power or to be free from the constitutional prohibition. That's the definition, my Lord. In this case, coming to the Act, when you look at the sections under this issue, surely, and the amendment of Article 105, where they purported to entrench it, you will discover that actually Parliament amended Articles 1 by adding there some new matters. For example, in Article 1, in my opinion, they added there another clause 5 to read that Parliament shall have power to determine who shall govern the people of Uganda, provided that is supported by 2/3 of the Parliament. That's the majority rule. And under Article 2, they could have added another sub-article to read that although the Constitution is supreme, Parliament may determine when it may not be supreme. And by entrenching the term limits, they amended Article 260, because Article 260 says for anything to be entrenched, it must be subject to a referendum. In this case, my Lord, no referendum was held. In absence of that referendum, definitely there was nothing. And because there was no referendum, because I've said that they amended those articles, surely there was need for them to separate the second and third sittings with 14 sittings of Parliament, which, my Lord, they did not do. And my Lord, it is clear from the Hansard that Parliament actually directly amended Article 260 of the Constitution. My Lord, when you go to page minus 21 of the answer, this is Honorable Maje's reporting from the Committee of the Whole House, reporting now to the Parliament. He said, I beg to report that the Committee of the Whole House has considered the bill entitled and passed the entire bill with amendments, and also introduced and passed new clauses, amending Article 77, 181, 29, 291, 105, and 260. So the emphasis now is 260. Because 260 from the answer is clear that it was amended. And even after being aware that 260 is amended, the Speaker never bothered. Because at this point, she should have said, members, since we are amending Article 260, let's separate the two sittings. She did not. And to me, that they abdicated her constitutional duty. Because she was elected to do that. So, my Lord, in absence of that separation, everything was null and void. And my Lord, the bill cannot be separated. We cannot separate between some parts and then we cannot separate it. The whole of it goes. Because if a bill is affected by a section which is brought in unconstitutional, the whole of it has to go. My Lord, that brings me again to the certificate by the Speaker. In the discovered documents, the Speaker has a certificate of compliance. And my Lord, this certificate has several issues. One, the Speaker only names 4 articles as being amended. Yet actually, and in actual sense, they amended more than that. So my Lord, the question is, a certificate which is defective, a certificate which conceals the material facts on the Hansard, can it be a certificate, my Lord? Because this certificate, my Lord, only talks about Article 61, 102, 104, and 183.
I think that's the argument, Mr. Mbale. So that's a good one. I think the argument, I would put it, that the certificate is insufficient to cover the articles that are not mentioned therein. Therefore, the articles which are not mentioned in the certificate remain without the certificate.
Thank you, my Lord. And my addition is a certificate.
But you said the other articles like 1 and 2?
1, 2, and 260
are actually amended by implication.
Yes, and 260 directly.
Let's talk about the 2. But it is not included in the certificate 260.
Yes, it's not included in the certificate.
Okay. Now
Even 77.
How about 1 and 2?
1 and 2.
Did you expect the Speaker to say in the certificate these ones were directly amended? 1 and 2 amended by implication.
If she was really a patriotic speaker,
you see, that is
who is open to speaking the truth.
No, Mr. Mbale, I'm just helping you. It is not every day that we fail to do something that it is because of non-patriotic tendencies in us. I may come up with a judgment which favors you and does not favor the Attorney General. It would be sad if the Attorney General jumped up and said, this judge is not patriotic. And then another issue, I determine in favor of the Attorney General. Now you say this judge has stopped being patriotic, he's not patriotic. It's not about patriotism. But if you think somebody failed in this or what you say, he failed.
To make it better, she failed in her constitutional duty. Because Article 263(1) makes it compulsory. Actually, 200.
That's okay, but you see, as a people, let us also accept that we can fail. Really, I don't know. This is my personal view. We extend too much certain things. We read too much in certain things. Somebody fails to do something, there's ulterior motive. I don't want to go back to what we discussed the other time, where court comes to Mbale, in accordance with the law, the rules are very clear. Somebody says, no, you were just appointed yesterday, how can you take me to Mbale? The rules don't say I must be this day for 10 years before I do that. Even if I was appointed today, he would say that. I think somebody makes it an issue. Somebody says, oh, the trial of this petition must be done at the scene of crime. I thought the scene of crime, if there was one, was the chambers of parliament. So should we have got to sit in, in the chambers? So some of these things are not necessary. I'm just advising you. We will not give you a judgment because you've used those words. Similarly, we will not deny you judgment because you used this word. But I think you can be more helpful to yourself and to us. Just tell us that this was her mandate, these were her duties, she failed to exercise them, and want court to find so. You go to the next.
Most obliged, my lord.
Yes. These superlatives are...
My lord, so my submission is, the certificate is not sufficient. First of all, to amend those articles which are not mentioned. But second, my submission is, since the certificate is the constitutional requirement, any defect in it invalidates each and every thing in that bill. My last submission, my lord, is on the principle of constitutional replacement. My lord, I've extensively dealt with this principle.
And you had eaten up the 10 minutes, I'll give you 5.
Most obliged.
Do that.
My lord,
because you're arguing well, so I'll give you 5 more.
Thank you, my lord. So, my lord, I'm dealing with the principle of constitutional replacement, and I'm dealing with it from my index 242. And I'm going to rely on a published article in the International Journal of Constitutional Law, volume 11.
Have you included it in the...
Yes, my lord. That article.
That article is...
Yes, it's in my authorities. This article, my lord, was written by Carlos Banel. Carlos, as in Carlos Banel, is B-E-R-N-A-L. The heading is Unconstitutional Constitutional Amendments in the case study of Colombia, an analysis of the justification and meaning of the constitutional replacement doctrine. It was published in the International Journal of Constitutional Law, volume 11, volume 2, on 1st April 2013. This land author said that an amendment is a partial constitutional replacement if it is of great transcendence and magnitude for the system. An example of it would be an amendment establishing a monarchy. The third clarification was that the plaintiff has the burden to prove that the amendment is the mistake on the monarchy. So it gives an example that where you have an amendment which goes far beyond, it means the constitution has been replaced. My lord, looking at this act, the constitution was replaced. And my lord, at my index 242, this author sets out a 7-tier test. How do you determine that actually the constitution was replaced and not merely amended? And I'm going to be speaking to them. His first test is that you have to state...
We're talking of the entire constitution.
Yes. I'm saying by amending, by this bill, the entire constitution was replaced. Because its core was...
So Uganda has no constitution?
Right from now, not. Because the constitution...
I thought you would say there is now a new constitution.
There is now a new constitution.
One second to the...
which was passed by this parliament. This parliament also itself in the Constitutional Assembly used the force, we shall argue that, to bring in a new constitution where they cannot be elected.
When a new constitution comes into place using this method which you are attacking,
yes.
What does the author say? It must be challenged, and the court must declare it null and void, something like that.
This author even opposes Kelsen theory.
How about if Parliament, using an act of Parliament, introduces something new, like the term limit?
My lord,
which assuming it is popular with the people, so you cannot stand more than twice, however good you are. So does the article say even however good the amendment is?
Yes.
It must be rejected.
My lord, actually, in some other case, the merits and demerits of the amendment do not matter. As long as the amendment is illegal, you don't talk about the sugar which is coated on it. Because this term limit thing is just sugar coated on it. But at the end of the day, it was substantially changed. You have a different constitution. Because, my lord, the framers of the constitution, they had their tenets. And let me go through these principles, and I'm going to show you.
I thought that is what the council
It did not state this, the test. I'm talking about the test to be applied for you to understand that there was a replacement.
Better conclude now. Let's conclude. Wind up.
Yes, the first one is stating what is the essential element of the constitution that is at stake. In this case, my lord, there are two elements of the constitution which are at stake. The first one, sovereignty of the people. The second one, the qualifications or capacity of the president, who is also the fountain of honor. Those are big elements in our constitution. The qualifications and capacity of a president, who is also the fountain of honor, is a fundamental pillar in the constitution. He says that too, that we must state how the essential element underpins several constitutional provisions. So that those essential elements, I'm going to show how they underpin. On the sovereignty, you see they underpin Articles 1, 2, 3, 5.1, 8A, 59.1, 69.1, 77.2, 77.3, 77.4, 83.1B, 83.1H, 84.1, 96, 1031, 1071A, 126.1, 127, 176 2C, 181.4, 260, 262, 263 of the Constitution. So in just dealing with sovereignty, all these articles were overthrown by this amendment. When you come to qualifications of the fountain of honor, the following articles are underpinned: 16.3A, 51.2, 61, 91.1, 95.1, 98.1, 98.2, 98.4, 99.1, 99.2, 99.3, 99.4, 99.5, 100, 1011, 1012, 1031, 1034, 1035, 1041, 1051, 1052, 1056, 106, 107. Almost. That's what I'm trying to say.
So, Mr. Mbale, order, please. Please, order, please. I need to remind the court. It is permissible to laugh, but not to roar and take your time. Something might just a snap, and then we continue with business. It's human to get excited, but please do not.
My lord,
even in Parliament, you can't clap, for example. You must stamp your foot down because noise is adverse to Parliament. So what I'm saying is, please finish. Even the time I've given you.
My lord, I wanted to finish these articles, then I conclude.
Then you do what?
I conclude.
Then you do what?
I conclude.
No, you see, the thing is, my lord told you that what you are submitting on is on record.
So my lord, my submission.
You are now duplicating. You're going to be on record twice.
These articles are not there. Because I found that before, when I was just coming.
Yeah, but isn't it like an authority? You are a right.
Of course, the authorities are there.
Isn't it in your bundles?
So my lord.
No, isn't it in your bundles of authorities?
It is there.
Then how can you say it is not there?
My lord, my submission.
So conclude.
My conclusion is this, on this issue. I call upon you, my lord, to find that actually Parliament did caliber legislation for Articles 1 and 2, and actually look at the Hansard, it amended Article 260 directly without separating the two sittings of Parliament with 14 sitting days of Parliament, and without referring the matter to referendum before the assent. And by that, Parliament did caliber legislation, and it did what we call constitutional replacement, overthrew the Constitution. The reason why, my lords, we should throw out that amendment so that we retain the Constitution as it was. Thank you, my lord, for your patience.
Thank you. Just one question for you.
Bye, Sarah. Bye. friends who told me to take an aspirin before sex so that I don't get pregnant. Now look at me, pregnant, out of school, and I almost lost my life to this pregnancy. Young people have suffered in silence.
End the silence today. Speak up about the sexual and reproductive health issues affecting Uganda's youth and save a life. Silence is deadly. Speak up.
The silence ends now.
Brought to you by the Ministry of Health in partnership with Voices for Health.
Sorry, there just isn't any opportunity. If opportunity won't come to me, I'll create it.
Have no fear, the opportunities are endless with super data and swift bundles on MTN Pulse. Hit star 157# to join MTN Pulse and activate Pulse bundles.
Everywhere you go, MTN.
Boom, chicka boom, chicka boom, 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 chicka boom, chicka boom, boom, bounce for me. Who's the dude buzzing along up in the hot fire? Hey boy, taste the feeling, new boy. You put the clock on you, boy. You can't miss my friend. You get knocked down, get up again. Boom, chicka boom, chicka boom, boom. Hey boy.
To successfully transition from campus to your dream job, you need the right connections. And it all starts at the NSSF and Daily Monitor Career Expo. So come, interact with established entrepreneurs and corporate executives and get hooked with the opportunities to enable you build a strong business empire or corporate career. This year's Career Expo will take place at 11 universities around the country between 1st March and 6th April 2018. Don't miss this career building opportunity. Visit nssfug.org or check press and posters to find out when the expo will visit your campus. The 2018 Career Expo is proudly brought to you by Daily Monitor and
NSSF, a better life.
Honey.